Hello. Welcome, everyone, and thanks for joining us at the Six Bridges Book Festival this evening. My name is John Williams. I am an attorney here in town and also active with the local ACLU chapter, as we'll see has some relevance. I want to put aside a piece of housekeeping before we get going. People are welcome to ask questions at this session, as they are at all sessions. If you want to put any questions you have that may occur to you during the conversation tonight in the chat function, then I will get to those, and we'll have about 15 minutes at the end to ask some of those. So please feel free. But right now, it's my real pleasure to introduce Jorge Contreras to discuss his book, The Genome Defense: Inside the Epic Legal Battle to Determine Who Owns Your DNA. Professor Contreras teaches at the University of Utah College of Law, where he directs the program on intellectual property and technology law. And rather than rattling off his various appointments and publications, I'll just say that he is an expert on patent law with a long background in that field, and as both a practitioner and a teacher. And as you might expect, he has many academic and technical publications, but the book we're here to discuss tonight is not technical in the least. In fact, it's a legal page turner, and one that I would recommend highly to anyone who has an interest in science, who has an interest in law, or who has an interest in the business of scientific innovation. It's partially a primer on biotechnology and genetics. It's partially a business story, but it's mostly a human story of how a number of researchers and regular people, with the help of the ACLU, came to challenge corporate ownership of our genetic materials. And so, if I understand correctly, this is also Professor Contreras' first book aimed at a wider, more general audience. And so I'd like to ask him if you just say a little bit more about yourself and how you came to write this particular book.
Hey, John. No, thanks very much for that introduction and for the question, and also for the invitation to participate in this festival. This is a really big honor, and I'm thrilled to be here. Sorry I can't be there with you in person, but maybe next year. But in any event, as John mentioned, I've been a patent lawyer. I'm a law professor. I study patent law. And, with some justification, most people probably have the impression that this is kind of a boring area. And, to some degree, that's true. But this case was different. And I saw this case coming probably years, 4 or 5 years before it was brought. I knew that there was something that was going to happen in this area, and I was watching it very closely. And the more that happened, and the more stuff that accumulated around this case, the more interesting it became. And as it proceeded through the courts, I began to think, this is a case that's important, not just to patent lawyers or scientists or even venture capitalists, but really to everybody. And so I tried to think about how I could tell the story of what was happening in a relatable way that literally anybody who understands some basics about the law could understand and appreciate. And that's what I've tried to do here. I tried to explain what was going on, but I also went out, I interviewed close to 100 people, the lawyers, the judges, the patients, the doctors, the scientists who were involved, to try to understand and tell everybody else how they, how they made this happen, and what the human story was behind this important lawsuit. So
this book is about, I guess, broadly speaking, the patenting of genes. Is that fair to say?
Yeah, absolutely.
So why, and genes are, they're in our body. This is material in our body that occurs naturally. Why would anyone want to patent a gene? What kind of is the history of that practice, and what are sort of the applications of it?
Yeah, so the why is pretty clear, because if you can patent a gene, and we each have, a little over 20,000 genes in each of our cells. If you can patent one of them, then every diagnostic test, drug, therapeutic, vaccine that is made using that gene, or somehow detects that gene, you have an exclusive right to it, right? So what is a patent? right? A patent is this right granted by the US government that gives its owner for 20 years the exclusive right in the country to make, use, or sell whatever that invention is, so to speak, right? And so if you invent a new type of synthetic fiber, rayon or polyester, and you patent it, then everything that's made with that fiber, whether it's socks or a shirt or a parachute or a Tupperware containers for your kitchen, all of those uses, you can control them. Nobody else can do it without either paying you something for the right to use that material or risking a lawsuit when you sue them for infringing the patent. And so instead of a synthetic fiber or a new metallic alloy or something like that, what if the thing that got patented was a human gene? There are enormous financial benefits that will come to whoever owns that patent.
So let's talk a little bit about the patent issue here. What did Myriad do with its patent? What was it able to translate its patent into in terms of tests or profit for itself or scientific research?
Yeah, so again, we've got 20,000 or so genes in our bodies, in our cells. The ones that are at issue here are called BRCA1 and 2, or the BRCA 1 and 2. And the BR and the CA stand for breast cancer. So for many years, for over a century, doctors and scientists knew that there must be some hereditary connection between some families where breast cancer was very prevalent and something in their bodies, right? They didn't know what it was. It wasn't until the 80s, the 1980s, that genetic technology had advanced to a point where we could start to try to figure out, well, what exactly is causing these high rates of breast cancer in some families? There must be a gene that is causing this. And so scientists around the world were hunting for this gene. In 1990, a researcher named Mary Claire King at Berkeley kind of got the first clue to where this gene might be. We've got 23 chromosomes in our cells, right? That's why 23andMe is this company that we've probably all heard of. 23 chromosomes. She pinpointed the general neighborhood of this BRCA gene to somewhere on the long arm of chromosome 17. And that announcement, which she made in 1990, sparked this international race to find and determine the exact genetic sequence of the BRCA gene. It was a 4-year-long race. It was actually pretty difficult to do this back then. Universities, research centers around the world participated in this race. And eventually, after 4 years, the one who won this race was a company called Myriad Genetics, a spin out from the University of Utah. Some Utah researchers founded it with venture capitalists, with backing from Eli Lilly Company. And they were the first ones to determine the sequence and the location of this gene. They immediately got a patent. Okay, the company was formed to find this gene and to get that patent, right? That was its whole purpose in life. Why is that? Well, because breast cancer obviously is a really deadly and prevalent disease. And if you could find whatever the variants, the mutations were in that gene that were causing breast cancer in people, you could do a number of things. You could create a test that would tell a person, a woman generally, whether or not she had one of these mutations. And if she did, well, then she's got a very high risk of getting breast cancer sometime during her life. And then she can take appropriate measures, prophylactic measures, which could range from drug treatment, drug regimen, to prophylactic surgery, prophylactic removal of the breast tissue and or the ovaries if certain mutations that related to ovarian cancer were detected. That's a big market. Second thing you could do is make a drug. Curing breast cancer, we haven't done it yet, but back in the 90s, when all this was happening, they thought, look, if we know the sequence of this gene, maybe we can create a drug that'll cure breast cancer. That was Eli Lilly's interest in this story. That would have been a multi-billion-dollar market. Myriad, small company out here in Utah, decided the diagnostic test market was what it was going to go after. And so it made a diagnostic test and, was able successfully to test many women to see whether or not they had these deleterious mutations in this gene that was going to give them this high risk of breast cancer.
So patents are of long-standing. Patents are in the Constitution, and was Myriad abusing the patent system when it decided to try to patent these genes?
No, I don't think so, because Myriad was certainly not the only one. There were lots of genes that were being discovered in the late 80s and the early 90s, and they were all being patented. The patent office allowed this. And excuse me, you might ask, like, how is that possible? Like, this is not like a new synthetic fiber or a new metallic alloy. They didn't actually invent the gene. The gene was there. It was in somebody's body. In fact, this BRCA gene, we all have it. Every human has this gene. So how can you patent it? And the trick, and this was called a lawyer's trick by one of the judges who heard this case, is, okay, we've got a rule in patent law that says you can't just patent something that you find out in nature, right? So I'm an explorer, I go out into the jungle, I find a new type of mushroom, right, that no one has ever seen before. And I realize this mushroom, this is actually, I rub it on my skin and it, it heals a burn on my arm. Right? That's great. I'm going to patent this. Can I patent that mushroom? And the answer is no, because I didn't invent the mushroom. I just found it out there in the forest. It's called the product of nature doctrine. And so even if I cut the mushroom up from the jungle floor and bring it out with me and I wash it and get all the dirt and the bugs off of it, I've somewhat purified it, I still can't patent it. Okay, so what about human genes? They're in our cells, every one of us, we've got trillions of copies in our bodies. How do you patent it? Well, each of these genes is located somewhere in one of these 23 chromosomes. And the chromosomes are these big, long strings of DNA where all the genes are stuck together. And in between the genes, there's a bunch of other DNA that we don't know what it does really. It may do nothing. We call it, or we used to call it junk DNA. We're gradually appreciating that it does more and more stuff that we're finding out about, but they're all stuck together in these very long chains. If I took one of these genes and broke it out of the chain and then did that in the laboratory, so I've got this freestanding, free-floating gene in my petri dish in the lab, that's different. That doesn't exist in nature, right? In nature, the genes are all stuck together in this big, long chain. If I yank one out of the chain in the laboratory, purify it, and then I reproduce it, I have to make like millions of copies of it to do anything. Then my petri dish full of millions of copies of this gene has something in it that didn't exist in nature. And so the patent office bought that argument back in the late 80s. And they said, look, maybe in your body, that gene's a product of nature, you can't patent it. But once it's outside of your body and isolated and purified, well, it's new, it doesn't exist in nature. So you can get a patent. And this started what was called a gold rush of gene patenting. Universities, research institutions all around the world started to discover these genes and patent them. So cystic fibrosis, another terrible hereditary disease, the CFTR gene that's responsible for cystic fibrosis was discovered by researchers at University of Michigan. They patented it right away, but they were generous with their patent, right? They basically let any other clinic or hospital or university that wanted to test for defects in the CFTR gene, they let them do it for a pretty modest fee. Another disease, Tay-Sachs disease. The gene for that, HEXA, was discovered at the National Institutes of Health. They decided they would just contribute, and they patented it. but they basically never enforced their patent. They said, we've got a patent, we hang it on the wall, we're proud of it, but we're not going to enforce it. So anybody can do a test, and these are, prenatal tests, screener tests that are done on parents, while they're considering getting pregnant, to see whether these hereditary diseases are going to show up in their children.
You have a wonderful chart in your book which talks about this. It's a very handy reference, and it lists about 15 major gene patents that existed as of 2008, so a few years before this litigation got going. And as you say, different inventors took different positions as to how open they would be with their intellectual property or with their patent. Myriad, I get the sense, didn't consider itself a bad actor. Obviously, it felt like it was doing a lot of good for women. It worked with insurance companies to try to get its test available to as many people as it possibly could, but it also had the profit motive to consider. And in the book, you put a real human face on some of the, the implications of its practices. Can you tell us a little bit about that? I mean, how would Myriad's practices affect real women who were trying to get this genetic testing?
Yeah. So, right, Myriad starts out as a company with a health motive, right? It's going to diagnose women who have these mutations so that they can get help and not get cancer. The problem was the price that they picked for this test. And, as a company, they've got to be cognizant of their shareholders' desires. They've got to make profits. And they decided they were going to charge a little over $3,000 for this test. And, it started out at $2,600, gradually crept up over the years. So, somewhere in the neighborhood of $3,000 for a test that, never cost more than a few $100s to perform. By the end, probably cost less than $100. So very profitable, right? This is a very profitable business for them. They underestimated how accepting the healthcare payment system would be of their test and their pricing, right? So at the beginning, it was very difficult for them to get insurance companies to pay for the test. And that includes the big federal programs, Medicare and Medicaid. Medicare, which is basically for patients in their 60s, wasn't that relevant because when you're getting tested for breast cancer or for these genes, you're usually younger. This is younger women who were getting tested, but Medicaid was very relevant. And every state, as you probably know, has its own Medicaid system, but most of them would not pay the price that Myriad was asking. So for example, in Massachusetts, Mass Health, which is the Medicaid provider, they said, Myriad, we understand you've got a good test here. It can be helpful for our policyholders, but we're not going to pay more than $1,500. And Myriad that and said, yep, price is $3,000. Sorry, we're not cutting the price in half for you. And there's this standoff, right? And like in any negotiation, Myriad's holding firm, and Massachusetts patients who are on Medicaid are not getting the test. And it's a really difficult situation because, the $3,000 test, it's expensive. Not everybody can afford it. Private insurers basically follow these federal programs a lot of the time. And so when Medicare and Medicaid aren't going to pay for the test, the private insurers aren't either. Myriad, of course, wanted insurers to pay for the test. They were out there negotiating with private insurers and gradually getting some of them to come on board. But that took, over a decade. If you're a woman who had a family history of breast cancer, you have an aunt who had breast cancer, your mother had breast cancer, your sister had breast cancer, you're getting the feeling that this runs in the family, you might be vulnerable also. But not everybody is going to get it, right? It's only a probability. And you get 2 copies of each gene, one from each parent. So if this mutation was running in your mother's side, and your father's side didn't carry it, you could be fine, right? So you're not going to get a prophylactic bilateral mastectomy just on the chance that you might have this gene mutation. You want the test, you've got to find out. But you can't afford it out of pocket, and you can't, your coverage is not going to cover it. So what do you do? It's a terrible situation. And there was a patient who I discuss in the book, who I interviewed several times, named Elizabeth Sirianni, who, educated woman in Massachusetts, actually worked in the insurance industry, knew her way around insurance, and had taken time off from work to raise her daughter. Was on Medicaid. Massachusetts had a pretty good Medicaid system, and then was confronted with the need to get this test, but she couldn't afford it. Well, I take that back. She potentially could afford it, but there's a rule in Medicaid states that say, that a provider cannot do balanced billing, right? They can't charge $3,000 for something, have Medicaid pay $1,500, and then collect the other $1,500 from the patient. That's not allowed as a matter of law. So the test couldn't even be offered to a Medicaid patient in Massachusetts, even if they could somehow have just used a credit card and gotten the other $1,500 that they needed. So people like Elizabeth Sirianni and many, many other women around the country were unable to get this test that they really needed.
So enter the ACLU. The ACLU brought this lawsuit, which might be surprising to a lot of people. I mean, we've been talking so far about science and business, and a lot of what we've been talking about doesn't have like an obvious impact on civil liberties. I mean, we can think of ways where DNA and its uses or misuses could have civil liberties implications. You talk a little bit about a bill to prevent the government or private corporations from using your genetic material to discriminate against you in terms of employment decisions or things like that in a predictive manner. But what is the civil liberties angle here, and why did the ACLU get involved in spearheading this lawsuit?
Yeah, this is one of the most fascinating things about this case, right? ACLU had been around for 100 years before this, never brought a patent case, and really didn't have any patent lawyers on its staff. So why did they do this? So after 9/11 in 2001, terrorist attacks on the United States, a lot of civil liberties issues arising there for a whole host of reasons. And the ACLU was very involved in some of these, disputes regarding Guantanamo and the Patriot Act and whatnot. They became very visible. And so they've raised a lot of money, so much that they were able to double the size of their staff, sort of in the 2002, 2003 timeframe. And one of the people that they hired was a science advisor. First time they ever had a science advisor, but they knew that these issues were coming down the pike. The ones that you mentioned, right? Police using DNA fingerprinting, the FBI keeping a DNA database of everybody in the country. They knew that sort of stuff was happening, or was about to become a big issue. And those are civil rights issues. So they did a search and looked for someone who they could hire as a science advisor. And the person they picked, they were very fortunate to pick a young woman out at Berkeley who had taken a break from a PhD program out there, was working at a nonprofit that did sort of genetic policy, bioethics issues, and they flew her out to New York to interview. They loved her. She thought it was really interesting, and she went to the ACLU as her first science advisor. Her name was Tanya Simoncelli, and she played a major, major role in this case, in this story. So she thought at first, she's going to be dealing with the types of issues you mentioned: DNA fingerprinting, identification of people, discrimination, and so forth. But she had gone to one of the first science policy undergraduate programs at Cornell University, and had heard about the patenting issues that were emerging, because those have been around for a while. And even though they weren't widely known around the country, there was a small community of bioethicists and patent policy people who knew about these, and she knew about them. And she, in talking with ACLU lawyers about what kinds of things the ACLU could do to get involved in science issues, she raises this issue with a guy named Chris Hansen, who's a very senior, like 30-year ACLU veteran, has done all sorts of important cases at ACLU, Brown versus Board of Education, the big internet porn case, Reno versus ACLU, very distinguished guy. And she goes to him to bounce ideas about what the ACLU can do in the civil rights area around biotech and science issues. And she tells him about gene patenting. At first, he doesn't even believe her, right? Because again, she's not a lawyer. I mean, he thinks she's just mistaken. She's got this all wrong. And of course, it turns out she doesn't. She does know what she's talking about. And she emails him some articles. And when he realizes that, oh, wow, she's right about this, he basically marches right back into her office and says, okay, this is a thing. Who can we sue? And this gets it kicked off. And he sees a real civil rights angle to this issue, right? It's preventing women from getting access to medical treatment, right? That's a civil rights issue. It's also a free speech and freedom of thought issue. Researchers, scientists can't research these genes if they're patented. A patent in the US, a patent allows you to stop all activity relating to whatever your patented thing is, including pure scientific research. So that's an angle. And he was pretty convinced by these. That the ACLU, it took a while, right, to get the rest of the ACLU on board with these issues. Again, they're an old organization. They are constantly being attacked by outside sources. So they stick by their policy playbook very, very closely. And they have policies, hundreds of policies, right, around things like, copyright law. Copyright's another intellectual property law, but copyright definitely has a relationship to free speech. And so they had brought copyright cases before. Patents, not so much. They had no policy on patents. And so there was this lengthy multi-year process that had to go on within the ACLU to even convince the leadership that they could bring this case. And that, it took about 4 years between the time Tanya Simoncelli walks into Chris Hansen's office and raises this and the date that they filed that case.
And once it was filed, it was litigated in I think a very ACLU way. There's a lot of publicity and there's a lot of storytelling. And I think it's probably done in a way that is different than your typical commercial dispute would be, litigated differently than if this had just arisen between two corporations. Do you feel that the way this was litigated had a meaningful impact on the outcome of the case?
I absolutely do. Absolutely. Had this been litigated like an ordinary patent case, there's nothing ordinary about this, and it certainly would not have come out the way that it did. And there was a publicity angle, which I'm happy to talk about more. That was huge, and it was also an unbelievable shock to Myriad and its law firm. Myriad went out and hired like one of the best, litigating firms in the country to represent it, and they had never seen anything like this in terms of a patent case, right? These are highly technical cases that, industry experts, some, analysts and biotech reporters and so forth are going to be interested. These guys had New York Times, front page stories. They were on 60 Minutes, the Today Show, and all of this was lined up. It was prepped. They had videos. Again, I'm happy to talk about some of this. They had a guy called the Story Finder who went around, interviewed the plaintiffs, made a video of them to publicly display that. And that did turn out, I think, to be quite influential. The way they picked their plaintiffs was very different from a typical patent case. With a typical patent case, you've got two companies, right? You've got the patent holder and you've got the infringer. I have a patent on a drug, and there's somebody who's making a generic version of that drug, and the drug's still on patent. I sue them. The generic manufacturer, they've got all kinds of defenses like, oh, your patent's no good. That was already invented by somebody else, or you abused your patent, you shouldn't be able to use it. Those are the types of defenses. No one had ever, in all of the years before this, challenged the very system of getting patents on human genes, right? This was the time the ACLU brought this lawsuit in 2009. The patent office had been issuing these patents for a quarter century. This was settled law. Nobody, no law firm would have even thought of challenging this well-established practice that had been going on for a generation, literally. It took complete outsiders who looked at the practice and said, this is ridiculous, this shouldn't be happening, to then challenge it. So yeah, this was a really unique case.
There's a great scene that kind of encapsulates the different approach the ACLU took, where you have Myriad's chief counsel sitting in his office one morning, coming to work early, which is when he gets his work done, and he gets a call first thing from a New York Times reporter telling him that he's about to be sued, and this is the way he learns about the lawsuit. They had run a publicity campaign before the suit even began, and were ready to bring their storytelling capacity to the litigation. Why Myriad? Why was Myriad the defendant they chose? Why this particular gene patent, or this particular genetic test? Was there something about that test, or was it just sort of happenstance? This is where they were able to find their plaintiffs.
No, it was extremely deliberate. The choice of the defendant was very deliberate. So, as I said, there were hundreds, if not thousands, of gene patents out there at this time. And they could have sued any one of them, right? They could have sued any university who had a patent. They could have sued the National Institutes of Health, anyone. Because the legal issue is the same, right? Every single one of these, the legal issue, can you patent this thing, or does a product of nature doctrine prevent you from getting the patent? Same issue, no matter which patent. So the choice of the defendant and the choice of the patents was purely tactical, right? So there were other good candidates, right? So remember the CFTR gene for cystic fibrosis, that would have made no sense to challenge University of Michigan, because they were letting everybody use their patent, right? They weren't charging anything for it hardly. So there's really no harm done. There were other companies at that point, though, who had taken even worse approaches than Myriad. And the sort of main contender for defendant for some of the people on the legal team was a gene that related to something called long QT syndrome, which is this pediatric cardiac arrhythmia that infants and young children develop. It's an irregularity in their heartbeat. It is often fatal. But if you diagnose it early enough, you can prevent it with beta blocker drugs, which are pretty common drugs. But they're not drugs that you're going to give to every kid in America. So to decide which children and infants should get beta blockers, you have to see which ones have this genetic defect that's giving them this cardiac arrhythmia. And this gene was patented, discovered also at the University of Utah, licensed to a company, but the company went bankrupt. And they just didn't do the marketing right. For whatever reason, they went bankrupt. And in the United States, when you're in bankruptcy, a trustee takes control of all of your assets to auction them off to the highest bidder. And to do that, the trustee here said, okay, well, while we're sorting this all out, no one is going to be using this patent. No one can do this diagnostic test. And so for 2 years, you couldn't do the test, and like children were dying, babies were dying because you weren't able to administer this, very routine test to see if they had this long QT syndrome. And that seemed very sympathetic to some people, right? I mean, sort of thinking about tort cases and whatnot, automobile case. If you've got babies who are dying, that's sympathetic. But Chris Hansen and the ACLU's top leadership decided no, you couldn't do long QT syndrome because nobody had heard of the disease except the few, very unfortunate families who were affected by it. And so to create a case that was going to get broad public appeal and judges and jurors around the country would have heard of it, they had to go for breast cancer, right? The most prevalent deadly disease in America, affects pretty much every family, right? I think every one of us knows someone who has had breast cancer, is related to someone, friends, coworkers, like you name it. Supreme Court justices like Sandra Day O'Connor had breast cancer, and as did the spouses of some of the other justices. And so it affected everybody. And since you could pretty much pick any gene, Myriad just appeared with this big, crosshairs on its forehead. They were the ones who had the breast cancer gene. They were also charging a lot for it. Women couldn't be tested. So, they set themselves up to be the defendant here.
Talked about the ACLU storytelling, but you do a really good job of storytelling yourself in this book. And I'm interested a little bit in your process for doing that. You mentioned that you talked to over 100 people who were involved in the case. And I think that allowed you to adopt a very clear descriptive style in the book. You almost feel like you're in the courtroom or in the room with the actors when you're reading the book. And I think that's an accomplishment. Tell me a little bit about your process of just putting this material together and interviewing people. Were people receptive to talking to you? Was this still a raw thing for them when you came to the book? And when did you really decide you wanted to write about this case? I know you have been following this issue for a long time.
I'd been following it for years before it happened, but it was, I had decided to write this book as the case was getting up to the Supreme Court, because by that time, so much had happened and it was such an incredible story already. I knew whatever happened at the Supreme Court, this was a really important story. And I ran a focus group. I was at American University at the time in DC, and I ran a focus group of women who were part of a support organization called FORCE, Facing Our Risk of Cancer Empowered. This is a support group for people who have a positive BRCA mutation test, right? They're the ones who have these mutations, which is like really difficult news to take, right? So this is a very important support network for these people. So I interviewed about 8 of these people together in kind of a focus group setting. And like, as they started to talk to me and tell me their stories, I thought, wow, there is so much more here than, a technical, legal, scientific story. This is really a human story. And, I'm going to try to tell this human story. And, so I interviewed them. And as the case went along, I interviewed more and more people. And most people were receptive. This also took a while, right? It took me 8 years over the course of this project. And there were some interruptions. I wasn't working on this every day. There were some years when I happened to move from American University to University of Utah, which is for completely unrelated reasons. Like I probably didn't do anything that year at all. I was packing boxes, and getting my new office set up. But so I found that with a little bit of time, it was especially okay. So the lawyers on both sides, talked to me, and I wanted to present a balanced picture, right? I wanted to present Myriad's side of the story too. And in a lot of the popular press, a short 300-word like article in a newspaper, they're not going to have much time to develop like what went on at the company. But these people at this company were acting kind of like any other biotech company would have. I don't think they were bad guys. So their lawyers were doing what lawyers do. I wanted to hear their story. And I was surprised that the lawyers from Jones Day, the lawyers from Myriad, a lot of the people at Myriad were willing to talk to me. There was some hesitation. The ACLU, some of the ACLU people were hesitant at first. The ACLU gets attacked a lot, and they didn't know who I was. And, was I going to try to smear them in some way? I hope I convinced everybody, at the end that, I was going to try to tell the honest story and use their own words to tell it and not editorialize too much. And, hopefully I succeeded with that. Like there were really only two major people who I really wanted to interview who did not return my calls. Barack Obama, right, who does appear in the book. Other people talked about him. My account of his role in the aftermath of this case comes from people who knew him and talked to him, but he didn't return my calls. And Angelina Jolie, right? She also appears in this book, and in a very important way. The ACLU lawyers did speak with her and did have contact with her, but she's obviously a movie star. Has a lot of stuff going on. Talking to some law professor is a low priority for her. But
she could do the time cover, but not the Genome Defense, huh?
Yeah, she did the time cover, and I actually paid a few $100 to time to use that illustration in the book. So I definitely wanted to use that illustration. It's a great photo.
Well, and I do think the sense of balance that you were going for came off well. I mean, I think that comes out in the appendix also, which is a little more technical, but I think just as interesting for anyone who is interested in this issue. And I think you make it, before I go on, I do want to add for our spectators that questions are welcome. And if you would like to go ahead and enter some in, I will direct those at George here in a few minutes. But I've got some other things to discuss too if you don't, so no pressure. But in the appendix, I mean, I think it's clear that you are not in favor of gene patents. I think you're pretty transparent about that. Yeah. But I also read you to say that companies like Myriad perhaps should have been able to patent the method by which they isolated the gene, which perhaps would have produced a similar result in terms of their ability to maintain their patents and control over testing. So, where do you come down on that? Can you explain that a little bit more?
Yeah, sure. So, right, the general patent on the gene that covers every possible use of the gene, I think that's much too broad. I think the patent office, they didn't know what was coming when they made these policies back in the late 80s, but I think they could have reined this in. So I do agree that the gene should have been patented. But there's a lot of other technology that's developed and good discoveries that are made that probably do deserve patents. That being said, a lot of this research was funded by the federal government and by public universities, right? So University of Utah, where a lot of these genes were discovered, we're a state university, right? The taxpayers of Utah fund this university, as does a lot of federal grant funding. Universities, especially public universities, have an educational mission. And I think that both the federal government and public universities could do more in restricting what companies do once they get licenses to these patents that are held by these public institutions, right? The university, so most of these patents were held by universities because that's where most of the basic research is done in the United States. And they then license them to industry because the university is not going to go into the drug testing business or pharmaceutical business. It can't do that. So it licenses these patents out to industry. There could be strings attached to those licenses, like you have to price your product at an affordable price. The NIH experimented with those types of restrictions in the past. They got a lot of pushback from the pharmaceutical industry, and they dropped those policies, but they didn't have to. And I continue to think that the government and the educational system could put a little more pressure on the companies that they license their discoveries to make them affordable and accessible.
So it's been about almost 10 years now since the Myriad decision came down. I mean, I think people understand at this point that the Supreme Court said you can't patent genes. And that sort of restricted the ability of companies to hold patents in a number of ways that they had for a long time before, 25 years, you said. In your estimate, how has this opinion either restricted innovation or not had some of the dire consequence that maybe some in the industry would have predicted? And what are some of the concrete ways that perhaps it has changed the way that biotechnology is developed?
Yeah, so it has certainly affected the ability of new companies to be formed around a particular gene or a patented gene, right? You couldn't get funding to form a Myriad today because, venture capitalists want the whatever they invest in to have exclusive rights to it, so they can make a lot of money. So business formation in the diagnostics area, it's been affected. However, I don't think that genetic testing has been affected that much, right? There's no genetic test that's not being given. It's that this testing is now being done by the large testing firms, Ambry, LabCorp, the same people that you send your blood sample to when you go to the doctor to test for your cholesterol level and, blood sugars and every other disease, that you might hear, STDs and so forth. These companies, these large testing laboratories test for thousands of different things. They can test relatively cheaply for these genetic defects also. So I don't think anybody can claim that fewer tests are being performed. It's just where they're being performed. Large testing companies rather than new venture-backed companies. Did that affect health in any way? Personally, I don't think so.
What about development of other technologies? I mean, do you think this decision stymied the development of technology in any way? I mean, you have a scene in the book from the oral argument where the court asks a question sort of like that, won't this stymie technology because the profit motive is a powerful one? And Chris Hansen answers something like, well, Nobel Prizes are also a powerful motive. There are other reasons people might do research, altruism, for example. Where do you think there have been negative implications from this decision?
Yeah, again, other than formation of new companies around these genetic patents, no, I don't. And I'll use an example from non-human DNA, right, or RNA. So if just because you can't patent the naturally occurring genetic sequence doesn't mean that there aren't lots and lots of technologies around that you can patent before you get to a drug or a vaccine of some kind. And a perfect case in point is COVID-19. So the SARS-CoV-2 virus was first identified in late 2019. Which again is after the Myriad case, right? So by 2019, we all pretty much know you can't patent this viral sequence, which by the way, before 2013, you could. And if you look at the history from SARS to MERS, even the hepatitis C virus, they were all patented, and those patents caused problems. Companies fought with each other, researchers couldn't get access to the organisms. That was all a problem. That did not happen with SARS-CoV-2. The sequence within a week after it was discovered, was uploaded to the public National Library of Medicine GenBank database. Researchers around the world were able to access it and study it. And we got vaccine, we got diagnostic tests within weeks of that. And then we got vaccines being tested within months of that. Now, the companies that made those vaccines, as you know, if you follow this area, there are lots of patents covering those vaccines, right? And there are patent fights erupting all over the world around the mRNA vaccines and, you know, the various technologies that are used in vaccine manufacturing. And Moderna is suing Pfizer and others are suing Moderna. There are plenty of patents. There's plenty of room for patenting in this space. So those patents, not to mention the huge procurement dollars that the US government and every other government is pouring into this, there are plenty of financial incentives to make these discoveries. But what wasn't needed was patents on the basic viral genome that it was better for everybody to have free access to, because, you know, who would have gotten the patent? The Wuhan Virology Institute was the one who identified the sequence. Would we feel better with the Wuhan Virology Institute being able to patent, you know, the SARS-CoV-2 RNA sequence? Like, no, I don't think anybody in America would have thought that's a good idea. Nevertheless, it seems to be what, you know, some people are arguing.
I'm glad you brought that example up. I was wondering about that. It just sounds like we should be grateful that the Supreme Court decided Myriad before 2019. It made things a lot easier. I
personally think so.
Well, I mean, the book, we have about 10 minutes to go. And again, if anyone has questions, I'm happy to direct them at George. But I want to conclude with a couple of questions, I think, with concerning the book's discussion of, I think, science more generally and its relationship to law. You know, I don't know if you've heard of the notion of law office history, which is sort of a pejorative term in constitutional cases to discuss, you know, bad history, contentious history to support results that the judges want to reach. I'm kind of wondering if there's a parallel notion of law office science and where you come down on the law's ability to do science. And I think you frame this nicely in the book with two noted jurists. Earlier in the book, you talk about Learned Hand, who seemed very confident in his ability to adjudicate scientific concepts. He noted the extraordinary condition of the law that makes it possible for a man without any knowledge of even the rudiments of chemistry to decide scientific questions. And then in the Myriad decision, you have Antonin Scalia, who refuses to even sign the part of the opinion that goes into the basics of the science, as if saying, I don't feel like I am competent to discuss this as a judge. Where do you come down on that? Do you think the law is able to adequately adjudicate science? I'm not talking so much about the patent court and the federal circuit, which has specific scientific knowledge on that court. I'm talking about the generalist courts.
Yeah, no, it's a good question. You know, the law, just by its nature, the law is always going to lag the science. Like, scientific discoveries will happen, technology will advance, and then a few years later, the cases start to come up. And I am an admirer and a supporter of the common law system that we have in this country. You know, I gotta come out and say it. It's not perfect, but I think it's the best thing. I think it's the best thing anyone has come up with yet, because we don't want a bunch of scientists deciding these cases. Like, yes, of course, they're going to understand the science better. But that doesn't matter so much, right? I think things like justice and fairness and equality are notions that judges have, that every lawyer should have instilled in them through their training. And then we should rely on litigators and experts to explain the science to us in some way that makes sense. So I don't think we need scientific courts. I don't think we need judges to be scientific experts. I mean, the problem is sometimes they get it wrong, right? They will get it wrong. Learned Hand, I think, got this wrong in that early 20th century case that I mentioned in the book. And that's going to happen. But the nice thing about the common law is that it can adapt, right? And it can change as we learn more. And we saw that happen in this case to some degree, like Learned Hand's decision, we moved past it and we've got a new decision here. I did talk to one of Justice Scalia's clerks about that, very witty concurring opinion that he made, which in an otherwise unanimous decision, right? I mean, for anyone who knows anything about the Supreme Court, this was a unanimous decision written by Justice Thomas. It's kind of a rare thing outside of the patent world. But Scalia, he is a little tongue-in-cheek, but he was also expressing some humility about this whole area. And I think there's no great answer. I think judges are humbled by the complex technologies and discoveries that they have to make decisions on. But again, I don't think I know a better way yet.
Yeah. Well, this is sort of to conclude where you begin your book, and on a similar theme. In the preface, you say that this is not just a book about Myriad or some legal patents, but also about how the law struggles to keep pace with scientific advances and how it can be moved in one direction or another by those who seize that opportunity. And I'm wondering if you could just close with some reflections on that topic and what you learned about that as you were working on the book and your views on that issue.
Yeah, it's, this case really taught me a lot of lessons and really gave me a great appreciation for how the legal system works here. Because, unlike civil law system sort of developed by bureaucrats and everything is baked into legislation, here individuals, people who have no connection to the system can look at the system and say, something's wrong here. This just doesn't feel right. We should bring a legal challenge, and they can, right? Everyone is entitled to show up in court and challenge a law. I mean, you've got to have standing, and there are big standing issues in this case, but if you've got someone who's injured, you can challenge a law and you can win, right? Like ordinary people can challenge laws that have been in place, a patent office policies that have been around for a quarter century, they can challenge it and win in the courts, which is remarkable, right? Go all the way to the US Supreme Court. That just doesn't happen everywhere. I think it's a remarkable system, and occasionally I think it works.
George, thank you for those thoughts. I've really enjoyed this conversation. The Genome Defense, everybody should go buy it. It's great. You're going to enjoy it. Thank you for attending this talk. And there's information in the chat about where you can get the book. Thank you again, George, for being with us, and best of luck to you. And I'll be interested to see what your next take on patent law might be for the general audience.
John, thanks so much. I really appreciate it.
Thanks.